A bombshell letter has just hit the court docket in the case of Blake Lively against Justin Baldoni, and people online are already calling him and his team schoolyard bullies. Blake Lively did her deposition on July 31st, and before things even really got underway, this was the headline in the medias. Blake Lively's deposition facing down her nemesis. Justin Baldoni's in the room. Most media outlets were posting that it was this unexpected surprise, although Blake's team had requested a list of all the attendees that were going to be there that day. Ezra Hudson, Blake Lively's lawyer, has now uploaded a letter to the judge in the court docket, and we know the actual story. It was not just Justin Baldoni who chose to go sit across from Blake Lively while she gave her deposition. It was literally his whole team. It turns out Blake had to tell her whole story of what's happened to her across from Justin Baldoni, Jamie Heath, Steve Sarowitz, his PR manager, Jennifer Abel, and his crisis manager, Melissa Nathan. Justin Baldoni's team had filed a letter the very next day after Blake's deposition. Now, this letter looked like it was in response to the subpoena that Blake's team had given to Brian Friedman's office. They used this opportunity to add in some of the confidential information that had happened in Blake Lively's deposition, and her lawyers are now calling them out for this, saying they only redacted a small portion, so it was very easy for people online reading this to know exactly what they were trying to get at. They also used adding some of her deposition to this as an opportunity to upload her entire deposition to the court docket. Now, if you follow any lawyers online, then you would have heard them talking about this because it's highly unusual for an entire deposition to be uploaded instead of just the 2 pages that would have referred to what they were talking about in this. This is the part being referred to where they did not redact the whole statement, instead just redacted a portion. And it says, upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then they list something that's redacted. This is the letter that Blake Lively's legal team has now uploaded to the docket, asking the court to strike Justin Baldoni's team's letter and the complete transcript of Blake Lively's deposition. This is what they write. Miss Lively respectfully moves to strike the Wayfarer defendant's letter attaching the entire uncertified rough draft transcript of Miss Lively's confidential July 31st, 2025 deposition testimony, and to deny the letter motion to seal as moot. In rushing to file on the public docket the entirety of the 292-page transcript on the day they received it, with no plausible legal reason to do so, the Wayfarer defendants and their counsel have proved Miss Lively's point. The transcript was apparently filed in support of their argument that there is no basis to assert that Brian Friedman or his firm have participated in, fueled, and advanced a smear campaign against Miss Lively such that their conduct has amounted to public relations work rather than that of an attorney. But, in fact, this tactic perfectly demonstrates the counsel as PR agent role because there is no conceivable legal purpose to file the whole transcript, particularly given that it has not even been reviewed, corrected, or finalized, and a mere 2 pages of it were cited in their argument. The letter and attachments should be seen for what they are, a manufactured excuse to force the transcript into the public domain as fodder for the Wayfarer defendants' media campaign. It is surely not lost on the Wayfarer defendants that, given the pending motion to seal, the burden is on Miss Lively to file a letter motion explaining the particular reasons for seeking to keep any of the 292 pages of the transcript under seal. Basically, what this is saying is because his team uploaded that whole thing, it's now on her with the burden to prove that it should be sealed. The Wayfarer defendants and their counsel hope to make Miss Lively defend the continued sealing of the transcript so they can advance a false narrative that Miss Lively is afraid of her deposition testimony becoming public, which is entirely untrue and deeply harmful. Miss Lively affirmatively pursued this litigation with the full intention and desire to have her testimony heard in a legal process, governed by the rules of evidence, which publicly filing this rough draft transcript in this manner substantially undermines. To suggest otherwise is part of an ongoing character attack that Mr. Friedman has been advancing to undermine Miss Lively's credibility and taint the jury pool. That is not a proper use of confidential discovery material or this court's docket. There's also a lot listed in the footnotes section as well, including a note about this redaction. It says, moreover, the Wayfair defendants compromised the confidentiality of the proceedings by applying only a single narrow redaction in their letter, while openly characterizing it in unredacted argument, substantially disclosing their spin on the alleged substance of Miss Lively's testimony. Accordingly, Miss Lively respectfully requests that the court strike the uncertified rough draft transcript from the record and order the Wayfair defendants to file only that portion of the transcript cited in their August 1st letter, which portion should be filed under seal, granting Miss Lively's motion to strike counsel's inflammatory letter because the sole purpose of the letter was to promote public scandal. This next paragraph is very interesting. It tells us exactly who was at that deposition. Consistent with their goal of creating a media circus around Miss Lively's deposition, it also appears the Wayfair defendants immediately leaked details from the deposition to the tabloid media. This began by selectively sharing from a source in the room that Mr. Baldoni was in attendance, apparently to advance a storyline that the deposition was a face-to-face showdown between Mr. Baldoni and Miss Lively. The next day, more leaks from a source close to the deposition described in detail Miss Lively's attire for the deposition, also revealing those who accompanied her, mocked Miss Lively's legal team, and then discussed extensively the Wayfair defendants' themes from their now dismissed case. The narrative created was that Miss Lively needed a large contingent of people with her to testify, while misleadingly suggesting that only Mr. Baldoni and Mr. Friedman were present for the deposition on their side. The reality is that Miss Lively testified across the table from Mr. Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel, all of whom attended this deposition in person, as well as 8 attorneys representing the Wayfair and Wallace parties, 2 of whom questioned her. And again, there's a lot in the footnotes of this as well. The first thing stated says, from the inception of this litigation, Mr. Friedman has falsely accused Miss Lively of being afraid to testify and delaying her deposition and has made a spectacle of it in a number of ways, including ghoulishly suggesting that the deposition take place at Madison Square Garden, as this court is well aware. The conduct leading up to the deposition resulted in the court granting a protective order governing the location and attendance at the deposition. The first time the deposition got pushed, the media went nuts saying that Blake Lively just didn't show up, that she was scared to do it. And in fact, now because of the court docket, we know what actually happened was the 2 parties, Justin's side and Blake's side, got together, discussed that they wanted more time, and they pushed it. The second time the extension happened, it became very evident that Blake was being blamed for this again, when in fact, according to the emails we saw, it was actually Justin's team that appeared to want the extension. Now, it actually did get extended because the judge ruled just that very day on the dismissal for Jed Wallace's claims based on jurisdiction, so they had no choice but to push her deposition a second time. This next part, they're saying, to be clear, Miss Lively's deposition transcript should remain confidential and under seal unless it becomes part of a legitimate filing. The law is clear that parties may not force material into public view by manufacturing reasons to file it on the public docket, as it's well established in the courts. It also says the deposition began at 10:13 a.m. Eastern Time, and this was posted at 10:15 a.m. Eastern Time, 2 minutes after the deposition began. Also interesting to note that one of the articles was published by this man, Kevin Perry at The Independent, who was listed in the media contacts at TAG, Melissa Nathan's company. Filing the uncertified rough draft of the deposition transcript when it serves no legitimate litigation purpose is disrespectful to the types of allegations at issue here and to the litigation process. It harms harassment and retaliation victims like Miss Lively, who already bear physical and mental health consequences from the underlying incidents and are forced to repeatedly relive the trauma through litigation, including court filings, depositions, and court testimony. And in this case, also through seeded press and social media gossip and scrutiny about her confidential testimony thanks to the Wayfair defendants. So all of them sitting across the table from her is turning out to not be a good look for Team Baldoni.